Hi, everyone, and happy 1010. I'm David Glazer, and I'm not really part of this, but I wanted to pop in because we're going to do something a little atypical for this health law webinar. We're going to cover a topic that's important to many of you, but about which us pure health lawyers know nothing. We're going to talk about basically hiring foreign resident physicians. And so today the webinar is going to be done by Deborah Schneider and Lon Nguyen, so two of our immigration lawyers, and they'll walk you through all the things that you need to know about hiring physicians. The only announcement we've got today is that the next month's webinar, which will be on November 14th, is going to be on fair market value analyses. And so Steve Beck and probably Jim Platt will be talking about how to do fair market value analysis. And so before I turn it over to Lon and Deborah, I just want to say these guys, we turn to them and they've helped a lot of our clients work out of either immigration pickles when they have arisen, for which Deborah Schneider was just in the New York Times, in fact, and also for figuring out how to get people into the country. And so they're really good at this, and Lon's going to start it off, and then she'll hand it over to Deborah. So enjoy the webinar.
Thank you, David. Good afternoon, everyone. Thank you for joining us today on this webinar, Hiring Foreign Resident Physicians, Conrad 30 Waivers and Alternatives. As David stated, my name is Lon Nguyen. I'm a partner at Fredrikson Environs Immigration Group, and joining me on the webinar is my partner, Deborah Schneider. We've worked extensively with our health law group in assisting some of our clients and with employers throughout the U.S. on immigration hiring strategies for healthcare workers with a particular focus on physicians. Before I start into the substantive materials, I just wanted to do some housekeeping. We will be taking questions at the end of the presentation, so please feel free to type in your questions throughout the presentation, and we will try as hard as we can to answer those questions. I'm also fighting a cold today, so if you hear coughing, I apologize for that, and I just wanted to give you a warning to expect that. Essentially, what we will do today is cover the issues that employers face when they are trying to hire foreign medical graduates as physicians. And we're going to focus significantly on the J. Conrad waiver program and the various options or requirements for it, along with discussing the non-immigrant work visa options that are available to employers if you do want to hire a foreign medical graduate physician. We will also address the green card options available to employers in sponsoring foreign medical graduates, and hopefully get some very interesting questions from everyone in the audience. I think one of the most helpful way for us to learn about what's going on out there in the real world is to really hear about real life case scenarios, and so we look forward to addressing some of those through your questions. Healthcare employers in the U.S. continue to recruit foreign national physicians in light of the continued shortage of physicians in the U.S. The Association of American Medical Colleges reported that based on current attendance and graduation rates, the U.S. could face a shortage of more than 150,000 physicians in the next 15 years. It is not surprising that 1 in 4 physicians in the U.S. obtain their education abroad, as healthcare employers recruit international medical graduates, IMGs, to fill their physician positions. The IMGs are foreign national physicians who are trained outside of the U.S. or Canada, and in order to practice medicine in the U.S., they must have a medical degree, obtain a ECFMG Educational Commission for Foreign Medical Graduates certificate, and complete a U.S.-based residency. So we're going to first talk about the visa options that are available to foreign medical graduates to enter the U.S. to pursue residencies in the U.S. The majority of international medical graduates coming to the U.S. do so for graduate medical education, which is a prerequisite for obtaining a medical license in the U.S. This includes periods of residency and or clinical fellowship. Normally, residency programs and fellowship programs allow international medical graduates to attend under the J1 exchange program, which is run by ECFMG. Now, the J1 exchange program requires that the physician must first pass steps 1 and 2 of the USMLE. There are foreign medical graduates who also enter in H-1B status, and I will discuss that later on. A J1 can be valid for up to 7 years with limited exceptions for extensions. This can pose issues with subspecialties which may require more years of training. All international medical doctors who enter on the J1 for graduate medical education will be subject to the IN 212E, what we call the 2-year residency requirement. This law requires the physician to return to his or her home country for 2 years before applying to work in the U.S. or before obtaining lawful permanent residence. This fulfills the exchange component of the J1 program. When applying for residency programs, physicians are fully aware of the 2-year residency requirement. The reason is, in order for the physician to obtain J1 status, the doctor will have presented a home country concurrent statement from their home country's Ministry of Health confirming that it has a need for the physician trained in this specific specialty, and the physician has filed a written statement that he or she will return to the home country to serve in that field for a minimum of 2 years. Physicians subject to the 212E residency requirement are not allowed to change their status while in the U.S. or obtain permanent residence without first fulfilling the 2-year requirement or obtaining a waiver of the 2-year home residence requirement. There are, as I also stated, situations where a foreign medical graduate can enter the U.S. under H-1B status to pursue a residency. Now, we don't see that as common as the J1 because with the H-1B program, there are certain criteria that the employer must meet in order to sponsor an individual in H-1B status. And then there's also the issue of whether an H-1B visa is available. I'm going to discuss the H-1B visa requirements and some of the limitations that the H-1B poses for employers later on. What we're going to do next, though, is talk about the situation that most employers face when they do make the decision as during the recruiting season to hire a foreign medical graduate physician. And these are the issues that we deal with day to day when we get phone calls from our clients asking, okay, I want to hire this physician. They're here in J1 status. How can we get them in to the U.S. on a work visa and on our staff? So I'm going to turn it over now to Deborah, and Deborah will give you a full review of the state Conrad 30 waiver program. Deborah?
Welcome, everyone. The state Conrad 30 program is exactly as it says. It's a federal program, but run by the states. So I'm going to talk about first what are similar among the states, what are the standard requirements that you're going to find no matter where your facility is located, and then I'll talk about some of the differences in the state programs and how may that impact your qualifications. So what you'll find is many foreign doctors come to the states. At the time they come here, they may believe they'll go home, and then circumstances change where they don't want to go back for 2 years and they want to find a way to remain in the U.S. and to work in their practice. So because of our shortage of physicians, Congress created a program that allows foreign nationals to apply for qualifying facilities to serve for a period of 3 years in health professional shortage areas or medically underserved areas or populations. This allows them to meet the unmet medical needs of the U.S. community in exchange of giving up their requirement to go home for 2 years. So in the last few years, states have also been authorized to use 10 slots in what they call flex waivers, or the flex program. This allows facilities who are not themselves located in health professional shortage areas or in medically underserved areas to qualify as a sponsor if they can show that they have a sufficient number of patients who they serve that reside in shortage areas and they have a much needed need to hire a physician. So the first thing you need to do is determine, do you qualify as a facility? Are you located in a shortage area, or do you have a sufficient patient population to qualify you? Each state has specific rules on what facilities and what types of doctors will qualify. Always remember, it's a state-run program and state-driven program. What may qualify a facility in Minnesota, for example, may not qualify a facility in Texas. The Conrad 30 process involves cooperation from the physician, the employer, and 3 different government agencies. The first is the physician. They're obligated to file for a waiver case number with the Department of State. This is a simple process that can be completed online with a small filing fee. The waiver number is used throughout the process to track the case throughout its filing. The physician will also need to provide copies of his or her DS 2019 and all immigration documents. They'll need to provide medical credentials and certifications, and depending on the state, show proof that a medical license has already been received or at least applied for. The doctor must also provide documentation to establish eligibility, including a curriculum vitae and letters of recommendation. The physician also must confirm it has no other waivers pending. They'll need to attest that they understand the J-waiver program, they agree to start employment within 90 days of receipt of the waiver, and if their home country funded their exchange program, they'll be required to get a no objection statement from their home country as well. The employer is considered the sponsor. They are actually responsible for nearly all components of the waiver program, as it's the employer who has to confirm they have the need for the physician and they're filling the needs of the community. The waiver is first submitted to the state public health department responsible for the Conrad 30 waiver program. Upon the state's recommendation, it's then sent to the Department of State for its recommendation. After the Department of State does its review and recommendation, it sends its recommendation to the U.S. Citizenship Immigration Services. The USCIS has the final adjudicatory decision-making over the waiver request. It will then also adjudicate the H-1B petition, which in conjunction with the waiver actually gives the physician employment authorization to begin work. So as you can see, you have a lot of government agencies and lots of players involved in this process. So beginning the process early is critical in order to get a waiver. So generally, the state is interested in acting as a interested government agency if the physician is truly going to meet the needs of the state. Most often, this will involve primary care physicians who work in health professional shortage areas. Many states still allow medically underserved areas or medically underserved populations to qualify, but we're seeing this trend go down. The facility must show that it's located in the shortage area, and some states have specific lists of what facilities qualify and what counties are designated. If you go to the state website, it's an excellent place to start to have an understanding of what each state requires. Many states will still grant waivers outside of primary care physicians and sponsor specialists if a showing can be made for a state need for the specialist in the area of employment. In addition, the facility must offer the doctor a 3-year written contract. The contract needs to include a minimum of 40 hours a week, and many states require the facility to offer a charity care or indigent care policy, because the goal of the state is to ensure all citizens would benefit from the doctor's services. Some states have a priority-based system, providing waivers first to highly ranked HPSA sites or safety net providers. The facility should also show its prior good faith efforts to recruit U.S. citizens for the position, and its long-term goal is to retain the physician beyond the 3-year period. For states accepting flex slots, the employer will have the added responsibility to prove that a sufficient number of patients live in these shortage-designated areas. It's up to the individual state to determine what would be considered a sufficient number. In these types of cases, I recommend more documentation to establish your true need for the physician services. For example, are there other healthcare providers in your area, or are you the only one? Have you been searching for physicians for over 6 months or a year to find this position? Can we document that? Do you have sufficient internal data that will help document the residence of your patients to show that in the past the facility has treated these patients in shortage areas?
Deborah, the flex area is one where we really have had to be creative, and I know you've had some really interesting cases. Can you give an example of a case scenario where you have pursued a flex slot waiver?
Yeah, and again, it's very state specific. In Minnesota, for example, The key really is to show that you have in the past served a sufficient number of patients living in these areas. And so we ask healthcare facilities to run patient data, to do it by address if they can. Obviously with HIPAA, we're not going to include the actual address, but we may look at street residents or zip codes. The hard part is HIPAA are only recorded by census tracts, so it's not an easy process to always verify each location to fit into census tracts, but we do. And if you can show that, within a 20-mile radius, we're the only hospital in this area, or we're the only one providing oncology care, and if without access to these doctors, they may have to travel an hour away, this may be a good fit. It's going to be very case specific, and so you really need to understand, what are the hospital's needs? How long are they waiting to see doctors? Are they sending in doctors from other clinics? Are patients waiting? Have they had a retirement recently of key personnel that they're having a very difficult time replacing? These would all be factors that may lean towards convincing the state that this is a good case for a flex waiver. You have to understand in Minnesota, this sits in the Office of Rural and Primary Care. And so their goal is to help make sure that rural areas are covered by physicians and, if possible, providing primary care service. We generally see a lot of these positions for hospitalists, internists, because those are very hard to fill positions, and it tends to be foreign medical physicians are the ones graduating in these fields, and they're able to fill these needs. So this is universal among all the states, is that you need to have a signed employment contract. Many states don't allow you to have a restrictive non-compete agreement in your contract, so that's something you'd want to evaluate before it's signed. Also make sure that the language contains the location where the physician will be practicing. It must include notation that it's a full-time 40-hour-a-week job, and that it should also include language that the doctor agrees to work within 90 days of the waiver's approval. Within the petition, you're going to be providing a detailed facility letter that explains why is this doctor needed. For example, include recruitment. If you've been running ads and you haven't had any applicants, show what steps you've taken. If physicians have recently left, explain the lack of physicians that you currently have. If there's been an increase in patients, or you're seeing a certain set of diseases or issues going on in your area, talk about why this doctor is there to meet this need. Explain how it's going to benefit the community. You may want to get letters from congressional representatives, from mayors, talking about the need to add doctors to these practice areas. You have to remember, the physician's probably only going to have one chance at a Conrad waiver, because they have to attest that they're only filing one waiver petition. This means you need to get it right the first time. So it's really just to make sure you're articulating what is the needs, why this doctor, and what are they going to do to help advance the state's unmet medical needs. And how you do this is in your support letter. Facility, you're going to describe your hospital or clinic, describe the services that you're offered when you're fully staffed, and describe what services you're not able to offer, or offer to the capacity you believe you could offer if you had more physicians. Talk about your patients. Who are they? Where do they come from? Where do they live? What are their income levels? What is their language barriers? What kind of income guidelines do they have? This may help explain why your facility deserves to hire another doctor. Do you accept indigent patients, Medicare and Medicaid, and a charity care policy? If you're a private practice who doesn't have a sliding fee scale for patients, you're probably not a good fit for this program, because the states are really, their goal is to meet the needs of the most underserved communities. And then make sure that the facility head understands the purpose of the Conrad waiver. Especially with big organizations, they want to know, where is this doctor located, and does the head of the facility understand the purpose of a Conrad waiver? They want to know that the doctor and the facility is aware that their goal is to treat the neediest of the patients. What we also do is we also tie in long-term plans for care for the doctor as well. We want to show the state, this isn't just a 3-year commitment. The hope is for the doctor to stay. What are they offering to help encourage the doctor to stay? Sometimes you may have spouses who also work in the area. Maybe you have children attending school. This to be a good fit for the practice and the physician for long term. In doing research on Conrad waivers, however, it is a state-run program, and you're going to see an entirely different process in different states. We've seen some states require a site visit. Some states require only primary care. They're not willing to accept specialty waivers. Some states charge fees to process the petition. Some states charge up to $2,500 just to submit an application. So some have a first in, first out basis, meaning the sooner you get your waiver petition in, you're more likely to get a waiver slot. And others have a completely separate basis based on merit. So they actually have a checklist, and they look at what's the ranking of your HPSA. Do you have a clientele, say, that speaks Spanish, and you have a physician that also speaks Spanish? Is that meeting a particular need? Are you associated with critical care industries or industry communities? Do you help provide to the lowest income? So you need to understand your facility. Some states, the waivers are used up within the first week of filing. For example, Texas, their waivers are already gone for this fiscal year. So you need to know, where you're located and what's the policy. Number one recommendation is to call the administrator. They run the program. They've set the rules for their state. They will know the region and your facility well, and they will want to understand before you file with them, what's the need that you're showing and how you can meet their rules. But the Conrad program works well. For the most part, nearly every state uses its 30 numbers, just at different periods of time. But the feds, they've renewed the Conrad waiver program for another 3 years. It is one of these congressional programs that have to be reauthorized, but it continues to do so, and we have seen changes. Usually when it's reauthorized, this one, it's fairly standard. Nothing has truly changed. But it's a welcome addition to communities who need doctors throughout the country. So what we recommend is if you have a foreign physician, you have a need, put in a call and we can review, is your facility qualify? What's our timing, and is there a slot available for you to make this work?
Deborah, before we move to, what happens after you get the Conrad waiver granted and everything, I thought it'd be helpful to talk about the fact that the timing of this, because I think it's really important. As you stated, Texas has run out of numbers already, and some states don't accept applications until a certain date. For example, Iowa will only accept applications as of October 1st, the first
Through November.
through the end of October, and it's first come, first served too. What, in terms of planning and everything, employers, are there situations where you could file before the beginning of the fiscal year and just have it sit there? And I know that we get a lot of questions also as to, well, what's the likelihood of, that's
Right.
one of the difficult issues we have to discuss with potential candidates along with our employer clients. What's the potential for success? And how would you address that in terms of helping employers prepare their candidates for those type of situations?
Yeah, it's hard because, these foreign physicians are also shopping around. They want security when they take a contract that they'll have a waiver go through because they only can try once for the most part. Generally, you're going to see applicants, before July when they finish their residency program, they're putting themselves on the market, so to speak, looking for positions. If possible, we would want to have a petition ready to be filed once the state accepts programs. The state is not going to want to hold on to petitions in advance. That ruins their process and procedures as first in. Everyone's going to fight to be the first in. Most states are October 1st. Some are September 1st. So again, know the state. And the goal would be to have it in as soon as possible. Minnesota is a state where numbers haven't been used as quickly. But it changes year to year. There was a year where back when it used to be a Flex 5, they were all received on the same day. There were no numbers. And you can about have a heart attack if you weren't one of those first ones in. But otherwise, if you do have a physician, you're looking at a contract, you want to start working on this as soon as possible. In terms of the success rate, if you're in a shortage area, your chances are very high if you move quickly, especially if you're in a rural area and your patients are going to be those that the state's most interested in serving. If you are a specialist, maybe working in a city where there's lots of others like you, you're going to need to take this into account. If you've never filed a waiver before, you're going to want to look through very carefully before you go through the process and expense and a contract with a doctor that it may not happen. Minnesota also, for example, if you have multiple applications for the same facility, as of last year, they were looking at one petition per month. So the facility needs to decide who's a priority filing their petitions, because you can't file 5 and expect that all will go through.
Okay, great. We are now going to go forward to discuss non-immigrant work visas for foreign national physicians and other healthcare workers. Now, as we all know, or for those who are granted the J. Conrad waiver, the employer will then file a non-immigrant H-1B work petition visa for the foreign national physician, and they're not subject to the H-1B cap, which I'm going to discuss later on. But before we move on into details regarding the H-1B, I'm going to go over quickly some other options that employers may have in order to hire foreign medical graduates who are in the U.S. So we have some technical difficulties here, but the H-1B specialty occupation, as I stated before, this chart lays out the type of visas available for employers to sponsor foreign medical graduates and other healthcare workers, and also whether it's employer specific or not. So with the H-1B specialty occupation work visa, it is employer specific. And what I mean is that in order for a foreign national worker to be in H-1B status, they need to have an employer who sponsors them. We get calls all the time where an employer will say to me, I have a candidate who's in H-1B status, and he says he doesn't need sponsorship and he can just transfer his H. And I respond, well, actually, he does need sponsorship. Yes, he can transfer his H to you, but you need to file your own separate H-1B petition. And if the employer is capped subject, meaning they need a H-1B number, then they don't need to have a H-1B visa number available because the foreign national has an existing H. So that's what they mean when they say transfer, but the employer still needs to file their own petition for the foreign national. There's the TN status for citizens of Mexico and Canada, and this is really the TN is part of the North American Free Trade Agreement, NAFTA, and there's only certain occupations that fit under the TN. And for physicians, only teaching positions would fit under the TN category, and not practicing physicians in medical facilities. Dentists also fits under the TN category too. So there are certain requirements that do need to be met for the TN, but that is an option for certain healthcare workers. The O1 extraordinary ability option is another one where a physician may be able to obtain an O1 petition based on the sponsorship of a petitioner, and Deborah's going to talk about that further in detail later. Other forms of work authorization that employers may see for healthcare workers is when a foreign student is on optional practical training or curricular practical training. And they get permission from the Immigration Service or the university to work for any employer in the U.S. We call it at-will employment, and that's always a great situation because the employer doesn't have to sponsor the individual except to offer the job offer. There's also J2, L2, and E2 categories, and these are categories where the individual is a dependent of a primary visa holder. The J2 is a spouse of a J1 exchange visitor. The L2 is the spouse of a intra-company transferee, and the E2 is the spouse of a treaty investor or treaty trader. And these individuals have work authorization in the United States. They do need to apply for an employment authorization card in order to, in certain situations, in order to establish employment eligibility. There's still some gray areas regarding this because many immigration practitioners believe that their work authorization is incident to their immigration status, and they shouldn't need to apply for a separate employment authorization document. But the Immigration Service has stated that in certain memos that they do need to apply for an EAD to meet the I-9 requirements. We also have the H3 or J1 trainee program, and these do require sponsorship too. I talked a little bit about the H-1B specialty occupation. Now, the H-1B is a work visa in which an individual job offer is a specialty occupation, and a specialty occupation is defined as a professional position which requires at minimum a bachelor's degree or equivalent, and the foreign national must possess a degree or equivalent in a related field. Okay.
Lon, what I hear from doctors often is that, well, I'm licensed in Iowa, I'll be transferring over, I'm going to apply, but they haven't had time yet to look at my application. I want you to go ahead and file my H-1B. How would you respond to those type of requests?
Where the individual hasn't obtained the license yet. In a situation where the state will only issue the license after showing proof of employment authorization, the Immigration Service will grant at least a 1-year employment period for those individuals, and then they will have time to obtain the licensing requirements after that. Okay, so as we stated, an individual who is subject to the 2-year residency requirement cannot apply for a H-1B unless they obtain a waiver first. And another issue that, so in those situations where they do obtain a waiver, the employer does not have to worry that they're a CAP subject employer or not because of the J. Conrad program and allowing for that to occur. And that is also, it's a great relief in light of the H-1B cap that we often face. Each year, there are only 65,000 visas that are issued for the H-1B process, and the employer needs to, at the time of hiring, if they are considering a candidate who perhaps is coming from a J. Conrad waiver program, whether they're CAP exempt or not CAP exempt, determine whether they can hire the individual because they may not qualify as a entity that is CAP exempt. There are specific entities that are not subject to the H-1B cap. And a few years ago, in around late 2010, we had a huge scare among immigration practitioners and healthcare facilities. And what had happened was that since 2006, or for a period of time, employers were applying for H-1B petitions and claiming CAP exemption because the facility, for example, had a teaching component, and it was a nonprofit entity that was related or affiliated with an institution of higher education. For example, a healthcare facility nonprofit where they took in residents from affiliated schools or schools within the area, and there was an affiliation contract. The Immigration Service would grant H-1B cap exemption to these entities. And then around 2010, there was a decision that was issued by the AAO, which is the appeals unit of the USCIS, where it stated that in order for a nonprofit to be a qualifying institution, they had to have some type of control or ownership component by the institution of higher education. And so we were seeing denials for healthcare facilities who previously were considered CAP exempt.
And Lon, what's the significance if you are a CAP subject employer? How does that change your ability to file H-1B petitions?
Well, if you are CAP exempt, what happens is, as I stated, 65,000 H-1B visas are issued annually. 20,000 of those H-1B visas are for U.S. master's degree holders. If you're not CAP exempt, there has to be a visa, and we have seen as recently as last year the fact that the H-1B numbers have run out very quickly. It's always a reflection of the economy. For fiscal year 2013, which started October 1st, the numbers for fiscal year 2013 ran out in June. I believe the magic date was June 11th, 2012, almost 2 months a couple of days after the beginning of the application period, which is April 1st. In light of what happened this year, I would definitely recommend that institutions or employers who are subject to the H-1B cap to file on April 1st. I think that we're going to see the numbers probably run out on the first day that we can file, and I'm hoping that there will not be a lottery process as has happened in previous years. But it appears that the economy is slowly improving, and it's reflected in the numbers of H-1Bs that are available. And right now we have a blackout until October 2013 for employers who are subject to the H-1B cap. So it was really important for these qualifying institutions to be considered cap exempt. And thankfully, what happened after the slew of denials in 2010 was the Immigration Service issued interim guidelines stating that it would give deference to prior H-1B cap exemption determinations for nonprofit entities made by the immigration since June 6, 2006. And so in preparing petitions where you're claiming cap exemption because you've previously been recognized as a cap-exempt nonprofit entity with a qualifying relationship or affiliation with a higher institution, it's very important to document it very clearly that you were previously recognized for the exemption, and there hasn't been any significant changes in the program that would make you no longer eligible as a affiliated or related institution. So Deborah, the next category is the O1 Extraordinary Ability category. Can you discuss what situations would a physician or a foreign medical graduate would pursue a O1 Extraordinary Ability visa?
And an O1 is a unique visa category in that when Congress wrote regulations restricting foreign medical graduates from changing status in the United States, it listed most of the working visa categories, such as an H-1B, an L visa, a TN, but it forgot to list or chose not to list the O1 category. So of course immigration attorneys jumped on this. So a doctor who is still subject to the 212E foreign residence requirement, who has not received a waiver of their 2-year residence requirement, is allowed to obtain an O1. So interesting, they can't change status to an O1, but they can apply for this visa category, return to their home country, request an O1 visa stamp in their passport, and come back in and work for a facility for 3 years initially, and the O1 can be renewed on an annual basis. So what we have found is many physicians who may be here on an O1 for 4 or 5 years, and then we learn they've never actually fulfilled their 2-year home residence requirement and aren't able to get green cards or change profession or do something different such as primary care work or treating patients because of their restrictions that they've never fulfilled their residence requirement. For certain doctors, however, this may be okay for them. This would be for doctors who are involved in research. O1s are not normally used for anyone involved in patient care, but involved for doctors who switch to a research component of their practice. There's no visa limit, there's no restrictions on how many O1s are received, but it has a very high category. The doctor has to show that they're considered extraordinary and at the top of their field. While many physicians think they are, we in fact have to prove that to the Immigration Service, and they are competing against other doctors and showing why they have established themselves at the top of their field. And there are specific categories they need to prove. There's actually 10 categories they have to show they meet 3 of these, and this can include showing evidence of original research, proof that they've spoken at numerous conferences, that they have international publications, that they've judged the works of their peers. So they would need to establish through documentary evidence why they consider themselves acclaimed in their particular research field as a physician and why they would be considered extraordinary. So with this, we would include letters from other experts in the field who can talk about their research. This works really well for those involved in clinical research studies, those working at universities, even some private practice if they have a highly research component. But if you have patient care, you're going to want to look at the H-1B category and definitely a Conrad waiver because that's what the whole process was designed for. In addition, so once you have a physician with you and you'd like to keep them for long term, the doctor's going to come to you, usually much sooner than they've ever completed their initial contract, and say, can you sponsor me for a green card? And sometimes when you get there, you'll need to look at what are the options that are out there. And I apologize. First, I want to mention if you don't have a waiver, so they didn't have a Conrad waiver, what are available for the physician in alternatives? And there's a few. One are interested government agency waivers. So in addition to the state, the federal government has established a few different programs that allow federal agencies to serve as a sponsor. This includes the Appalachian and Delta Regional Commissions, the Department of Health and Human Services, the Department of Interior for Indian Reservations, and the Department of Veteran Affairs. Only the Veterans Affairs hospitals do not have to be in underserved areas. Otherwise, you're going to need to still be located in a shortage area to qualify for those government waivers. Hardship waivers are not normally filed by the facility, but they're filed by the individual doctor. However, what we found is that we recommend, if you don't qualify for a Conrad waiver, is to find out from the doctor why they don't want to go home. What is so hard about returning home for 2 years and then coming back to establish their career in the United States? And often when we find out these particular reasons, they have enough facts to qualify for a hardship waiver. It's very fact specific. It's going to depend on the person's specific situation. But generally, we need to show exceptional hardship to a U.S. citizen or lawful permanent resident spouse or child if the doctor returned home to fulfill the 2-year requirement alone or with their family. Department of State will include this, will review this application, and then the Immigration Service. There's no state agency involved. And what they're looking at are factors such as health conditions. Is there a sick child that can't receive the type of quality medical care in their home country? Would they suffer discrimination back in their home country? Or certain women physicians, for example, in Saudi Arabia, can't practice their field the way they would expect to. Would it disrupt the career of the spouse, where they may lose their profession if they're gone for 2 years? Would they lose educational opportunity? Is there civil strife in the home company? What are the family ties to the U.S.? Would this cause severe economic repercussions? So if this is a physician you're really interested in, it's worth having an evaluation. We've had cases where they said, I don't think we're going to qualify, and we've been able to secure a waiver, and then the facility was able to hire the doctor soon after. What's quite rare, you don't see these often, is a waiver called a persecution waiver, and that's if the foreign physician has a fear of returning home due to persecution based on their race, religion, or political opinion. Depending on where the physician front and what's going on in the world today, I think you may see more of these happen right now with events going on in Middle East and in certain African countries. So it's case specific, but it's not. You don't want to forget about this, as it could be an option for you.
Great. Thanks, Deborah. We're going to move forward now to the green card process, and we're going to give you a brief overview of those that are available for employers to sponsor the physicians. As we quite often see at the very beginning of the negotiation process, where the employer has made a job offer to the foreign national physician, there's the discussion of green card sponsorship, and there are so many different available means to which an individual can obtain lawful permanent residence in the U.S. through employment or on their own. And we're going to go over some of them with you. The most popular one that is most commonly pursued by employers to sponsor foreign national workers, and we have done quite many of these for physicians, is the perm labor certification process, where the employer has to test the labor market to show that there are no qualified, willing, able U.S. worker to fill the position. It doesn't require employer sponsorship. The employer is responsible for all legal fees and administrative fees related to the perm labor certification, and that is part of the contract that we often assist employers with putting together when they do make the contract offer to the foreign national worker. For physicians who are subject to the or who are on J. Conrad waivers, it's really important to remember that even though the employer can start the perm labor certification process at any time before the completion of the 3-year commitment, and they can file an immigrant petition, which is the second step of the green card process. The foreign national physician who has a J. Conrad waiver cannot apply for lawful permanent residence by filing the I-45 application until the 3-year has been completed. We have seen situations where even the filing of a I-45 a day earlier than the end of the 3-year commitment will result in a denial, and the employer and the foreign national worker has control over that not to occur. So before you use a diagram regarding the perm labor certification process, now in certain situations where the foreign national has a visa number available, and if they were not subject to some type of Conrad waiver commitment, then you can apply for the green card at the same time that the employer files the I-140 petition if a visa number is available. And I mentioned visa number because there are visa backlogs for nationals of certain countries such as China and India, even in categories where the position requires advanced degree. So there's a lot of strategizing that needs to go into the discussion of assisting the foreign national obtain the green card process. And as I stated, there are many other options, and the perm labor certification process is just one of many. Deborah, you want to talk about the other types where a labor certification is not required?
Yeah, so there's a few options. One is national interest waiver, and those are for doctors who are working in our national interest. An outstanding researcher, these are for doctors who have shown sustained international acclaim for their research, or the extraordinary ability category, and these are for doctors who have proven that they're at the top of their field, very similar to the O1 category I talked about before. The outstanding researcher and extraordinary ability are what we call fast track to a green card, because it's what we call first preference, meaning there's no visa wait. These can be premium processed, which means for a bit of a bribery fee to the government of an additional $1,225, they'll actually make a decision on the case in 15 days, which is truly unheard of in most standard immigration processing. Lon, how long are labor certifications taking right now?
For labor certifications at the Department of Labor, it varies depending on whether the application is targeted for an audit or gets flagged for an audit. But I would estimate right now between 4 to 12 months, and it can change. In the past, we've seen petitions adjudicated within 2 months. We haven't seen that in a long, long time, though.
So for physicians, there's actually a special national interest waiver just for them. And the key is they have to show that they're employed as a clinical physician for 5 years in a HIPSA, a medically underserved area, or at a VA facility. What works well is if you are a rural clinic already in an HPSA and you've already had them working for you for 3 years under a Conrad waiver, that 3 years counts towards this 5 years. So if the physician signs another 2-year contract with you, that allows them to qualify for a national interest waiver, which is a good negotiating tool between the employer and the physician to keep them for a longer period of time in these underserved areas. You do need to show a full-time employment contract, show proof that you're working for the clinic, and then you also need agreement from a federal or state public health department stating that it agrees that the foreign physician's work is or will be in the public interest. And generally, if you're in a HIPSA and the doctor's already shown their commitment, they've already worked for you for 3 years, that's not that difficult to get. The doctor will have to show proof that it's satisfied the J1 home residence requirements. Again, this national interest waiver does not count as a waiver of the 2-year residence requirement. It would be the step after they've already waived their 2-year home residence requirement.
Deborah, before we move on to the next topic, I just want to remind everyone, please feel free to ask your questions and type in any questions that you may have as we're approaching towards the end of the program. We would love to answer any outstanding questions you may have. But, before we move to outstanding researcher, Deborah and I had a conversation before as to, well, what's the, why not go for the national interest waiver where you only have to show 5 years of service with the employer instead of having to have the employer go through the perm process of testing the labor market and then having to document and dealing with filing a labor certification with the Department of Labor, then going through the Immigration Service. And it really comes down to physicians want their green cards as soon as possible so they can have some type of stability and feel more secure in the U.S. So as Deborah stated, it's part of the negotiation process that employers really need to consider and address with the foreign national physicians at the beginning of the process as to what is the best strategy for the employer and for the foreign national so everyone can be on the same page.
And so if a physician qualifies, they may ask for the fast track green card. Again, these are only for those who are considered at the top of their field. And there's 2 separate categories. One is for outstanding researchers, which, as the title says, is for those engaged in research. And the second is the EB1, which does not have to be for researchers. That can be for internationally renowned doctors who are practicing, though likely if they're at that stage, they're also teaching and writing and publishing as well. Before an outstanding researcher, they need to show that they've had 3 years of experience, either teaching or conducting research. They need to be recognized internationally as outstanding in a specific academic area. They need to have either a tenured university position or proof that they will have long-term funding for their research project, or a comparable position, university or at a private institution. So what they're really looking for outstanding researchers is to show international acclaim, show the originality of their research, show proof that the employer wants to continue on with them, and there'll be a variety of documentation. What's nice about these is most of the work is all on the physician and the researcher. It's up to them to document their abilities and support it through substantial evidence. And the employer's job is just to offer them a position. There's no specific wage requirement. There's just that permanent offer of employment for them to continue on. Again, you're still looking at some level of extraordinary ability. It's a lower standard than the extraordinary ability category. You only have to show 2 of either winning awards, membership in associations which require outstanding achievement, that they've published material in professional international journals, that people have written about them or about their work, they've judged the works of others in a professional capacity, and that they've contributed original scientific and scholarly research. It's really the key factors that you're looking for. For extraordinary ability, we actually do these quite a bit for doctors coming into the U.S. when they work in very high level. So they could be the director of operations at an institution where they're no longer doing day-to-day patient care, but they've taken on a very high-level managerial role. Or maybe they've come up with the key publications or books in their topic. So if they've been practicing for many years, we have done these for recent graduates, I'll have to say, in particular specialties. If you come from a very prestigious institution, say you were chief resident, you've already had 12 publications to your name, you've had international speaking engagements, it may work for the doctor. This allows you to not only have a sponsor by the facility, but you can also self-petition. So even if you don't have an employer who wants to sponsor you, the physician can file this on their own and give them freedom and flexibility to continue on in their field as long as they can show they'll be continuing to work in their field. This is the hardest category to qualify for. So again, I've met many doctors who really think that they meet this category, and it takes a very careful analysis to determine if they're at this stage in their career. We hope you have enjoyed our webinar for today. We do have a survey we'd ask you to complete, but right now, if you have questions, please type them in the chat box, and Lon and I are available to answer them.
Deborah, you had mentioned, as we're waiting for questions, the fact that individuals who are petitioning under the extraordinary ability category, it's not employer specific, is it? Or because what we have seen, as you know, is let's say someone loses their employment at the time that they file their EB-1 extraordinary ability petition, they are employed, and then they are no longer associated with the same employer that that they were working for when they filed the petition. Will they still be able to qualify for the green card?
Yeah, the key for an EB1 is your field. So if you're an expert in oncology, if you change employers and you're still doing oncology work, you're still maintain that expertise. So that's not a problem. What we see, again, because these are fast-track petitions, you don't often have that issue as much as you do in other categories because, again, the lack of the visa wait. If you can get a decision in 2 weeks, you could immediately file for adjustment of status. And it's really at that adjustment of status stage that the Immigration Service wants proof that you're able to work in your field. So if you've just been, terminated or you're in between, that would not be good timing because you do have to show you're still working. But I would say for most parts, they're able to show they're working on publications or they're giving lectures. They're able to establish enough itinerary to show that they're still engaged in work in their field.
Great. And that would not be the case, would it, for outstanding researchers, where the outstanding researcher, for example, is being sponsored for a petition and then they're terminated?
Actually, an outstanding researcher can also take the petition with them if they can show they're also working in their field. Again, it's that same fast-track petition. Likely, it's only going to come up again at the adjustment stage. So we did receive a question asking, how does a Canadian national differ with the process? And I'm guessing, not entirely sure which process. We've talked quite a bit during our talk. But if it's, say, a Conrad waiver, Canadian physicians are still going to be subject to 212E if they received foreign medical education in the United States. What we have seen from some Canadians is they have tried to circumvent the Conrad waiver process by applying for an H and crossing through the border to come into the U.S. And how this happens is because the regulations as they're written says you can't change status in the U.S. or get a visa. But Canadians are visa-free. They don't have to have a visa stamp to come into the country. So what we have seen is that they may have applied for an H-1B, it was granted. They take that across the border and they begin working for an employer. That may be a temporary alternative, but it's still always there, this 2-year requirement. And what's happened is we've discovered when they've tried to get a green card, the Immigration Service knows this and it will find it out, and they're not able to get a green card or remain in the U.S. until they fulfill that requirement. So that's one difficulty that we've seen with Canadians. It may be a short term, but our recommendation is to clear up the 2-year residence requirement at the front end if you can. Lon, anything you want to add?
I think that also it may be, the question may pertain to requirements that the foreign national physician must have in order to come in to perform a residency requirement. We talked about international medical graduates as any individuals who are trained outside of the U.S. or Canada. So Canadians are different in regards to the licensing requirements for those who have received their medical education in Canada. And each case is fact specific. We have had to deal with individuals who may be from Canada but had their education in a foreign country outside of Canada, and it would still make them subject to the requirements for international medical graduates. I think we have some more questions,
Yeah.
right, Deborah?
So Lon, this question notes, if I have an H-1B physician who is halfway through her 3-year contract, at which point should I start the petition for the green card? Do I have to wait until she has completed the 3 years? And would she be able to continue to work while waiting for her green card? Or would she have to return home to await confirmation of her application?
Okay, in the situation where you have an existing H-1B for the physician, so they've gotten the waiver approved, the employer can start the green card process or the process for the perm labor certification at any time. The key is this. The key is that you can file the perm labor certification and obtain a I-140 immigrant petition approval for the foreign national, but they cannot go to the third step, which is the filing of the I-485 adjustment of status application, which is the green card application. So they must complete the 3-year commitment pursuant to the J. Conrad program before they can apply for adjustment of status. We just had a situation actually where the foreign physician, we filed this because the labor cert application process is taking at least 4 to 12 months after the filing, and then you have to take into consideration the recruitment period too. It could be about 1.5 years before you can even get to the stage where you can file the approved I-140 petition. And although you can get a approved I-140 petition within 15 days, you can also have the option of filing the I-140 petition and getting it approved and not having to pay the extra $1,225. So there's no requirement that you have to wait to start the labor cert. It's the requirement that they can't apply for the actual green card application adjustment of status until they complete their 3-year. And during the time that you apply for the green card, the foreign national can continue to work for you in their H-1B status. If they've complete their first 3 years of H-1B, you can extend the H-1B for as long as needed. Due to the visa backlog for certain nationals, such as Indian nationals, the waiting period could be about 6 years, where you reach the 6-year H-1B limitation. Luckily, there is a provision under the law which allows employers to extend the H-1B status for an additional 3 years if the employer has an approved I-140 immigrant petition for the foreign national, or if they filed the perm labor certification at least 365 days before the 6-year limitation.
Another question, this said, how can an O1 researcher justify a 212E waiver petition in a state that does not sponsor research waivers? Well, a researcher in this position would not qualify for a Conrad waiver. There are some federal waivers that do sponsor researchers that they might want to look at. The Department of Health and Human Services would be where I would look. We have done those on very concrete cases where the need was very great. We've done that for Ohio. Here, what we see is if someone's a researcher, generally they're going to put their research on hold and they're going to commit to practicing primary care for 3 years in order to waive it before they go back to their research, because they often don't have any other choice.
Great. I think that is all for the questions that we have today. Thank you so much for your time. And we look forward to working with many of you in the future. If you have any outstanding questions or need additional information, our contact information is there, and we will be happy to respond to any questions you may have offline by phone or by email. Thank you.
Thank you.